G'day everyone and welcome to video 4.1.7 for the legal studies guy. A bit of a tricky one today. I've already had a comment on YouTube asking for this one to be uploaded because it's a little bit confusing. So we'll delve into why it might be a little bit tricky as we start in a minute. But first of all, our quote for today from John D. Rockefeller. A few American quotes the last few days. Don't be afraid to give up the good to go for the great. AKA, don't settle. Don't be happy with to say things are good now. Don't always just be happy with that. Don't be afraid to try and strive for more. If you're if you're averaging 65 in your sacks and you're like, yeah, that's good, I'm okay with that. Don't be afraid to actually put yourself out there and strive for 75, 80 on the next sack. Put your best foot forward and go as hard as you can. So we are at dot point 4.1.7. This is the last dot point for area 4.1, and we are looking at the impact of international declarations and treaties on the interpretation of the external affairs power. And we need to be able to discuss the impact of international treaties on the interpretation of the external affairs power. Now, why this is an interesting dot point that's been added to the new study design is, from our last video, 4.1.6, we looked at a High Court case that impacted the division of powers. That was also a dot point in the old study design, and it used to ask us or tell us we needed to know two High Court cases that impacted the division of lawmaking powers. And pretty much across the board, every legal studies teacher I know taught a case called the Tasmanian Dams case. And we're going to look at that in these slides. And the Tasmanian Dams case is a case involving the external affairs power and the interpretation of that. So this dot point, whilst new, was one that was effectively taught in the old study design, but taught just as a High Court case and not particularly or specifically about more generally what's the impact of the external affairs power, what's the impact of international treaties. So we are going to look at that case after we just explain, quite simply, what impact international treaties have on the external affairs power. So we'll explain it first, and then we'll use a case to illustrate it. And then we'll look at the practice question that they actually included in the VCAR sample exam. The idea being that at the end of today, you should be able to answer what impact have international declarations and treaties had on the external affairs power. So a little bit of vocab to start. Our key terms here are international declarations and treaties. Obviously, external affairs, you can take that to mean foreign affairs, our relations with international countries and the international community, pretty straightforward. And that's been accepted by the High Court as the meaning of that. But international declarations and treaties. So the really important one, because most of the stuff we're going to cover is about treaties. Treaties are agreements between countries, and these agreements are binding. So that means you have to follow them. They're binding in international law. International organisations, the UN, subsidiaries of the UN, UNESCO, those sorts of things, may also be parties to treaties, so they might sign them as well. They're known by lots of things, but some of the common ones are conventions, covenants, protocols, they're sometimes called as well, but most often they're just called treaties. What we mean by binding in international law is that if you sign a treaty as a country and say the treaty has certain terms, like you must reduce your carbon emissions, so that's a lot of the treaties that are being proposed at the moment around the environment, you must lower your carbon emissions to this level or take action to. Binding in international law means that if you don't actually achieve or follow through on what the treaty says, there's the option or the potential of international sanctions being imposed upon you. So these are things like trade sanctions, so people won't trade with you, or international condemnation, that sort of thing. So the idea being that there is some incentive to make sure that you follow through on the treaty after you sign it. Otherwise, that might have a negative effect on your country. A declaration, on the other hand, is slightly different. Declarations are made by international organisations such as the UN, or again, UNESCO, UNICEF. They're guidelines for behaviour, but they're not internationally binding like a treaty is, so just slightly different. They may ultimately lead to a treaty being developed, but they're not a treaty in and of themselves. So the most famous example of a declaration is the Universal Declaration on Human Rights by the UN in 1948. This isn't a treaty, this isn't signed up to by international countries, isn't signed up to by Australia, therefore not binding in international law. But the Universal Declaration of Human Rights did lead to some development of some treaties, like the International Covenant on Civil and Political Rights, I think was one of them, that included a lot of the terms of the Universal Declaration of Human Rights. So declarations aren't binding in and of themselves, they're not signed up to, but they may lead to treaties which are signed up to. And we're going to focus on treaties, things that we sign up to as a country. So what's the process of making a treaty? And this is really, really important because we're going to talk a little bit of separation of powers here. 1, 2, 3 clear steps. The first step lies with the executive. So if we remember our separation of powers information, the executive is the government. So the political party that wins the most seats in the House of Representatives, the government, they effectively run the country. The senior members of that political party, the leader becomes the Prime Minister, the senior members become ministers with significant portfolios like trade, home affairs, that sort of thing. It is this group, the executive, that has the power to make and sign international treaties. Okay, so they can be like, yep, we want to agree to that treaty, or we want to sign that treaty, or we want to work with that country. So treaties can be both in, like, just between two countries, so a treaty between us and the United States, for example, or they might be multilateral multilateral, which means they're between more than two countries, so 3 or more countries. An example of a multilateral treaty is the ANZUS Treaty, Australia, New Zealand and US. We have a treaty about effectively helping each other in times of war and going to war together. Bilateral treaties might be trade agreements between countries, so on and so forth. Multilateral treaties can also be massive, like there's one about, it's called the Montreal Protocol. We're going to talk about that in a moment. It's about protecting the ozone layer, and it's actually signed up to by 197 countries, aka every country in the world is a signatory to that treaty. So treaties can be that big, or they can just be between two countries. So as I said, this is executed by the cabinet, the Prime Minister and senior ministers. They sign us up to the treaties under the executive power from Section 61 of the Constitution. The second step of the treaty making process, though, is then to determine if we need to change any of our laws. So say we sign up to a treaty that protects certain rights, or we sign up to a treaty that bans certain things, such as, an arms trade treaty or something like that. We then need to check our domestic laws, so our laws within Australia, and make sure that they actually meet the requirements of the treaty. So it's all good to sign a treaty to, limit the arms trade. But then what if we have a law in Australia that says, arms trading is all good? So you need to determine if we need to change our domestic laws or not, if they meet the terms of the treaty. And generally, most treaties won't require any action. So generally, the current laws in place will meet the terms of the treaty. Otherwise, it might just be executive action. So it might just be trade agreements. So it might just be, banning certain or removing certain restrictions and stuff like that. That don't need actual laws to be passed. So it's the responsibility of the executive and the departments only. But sometimes we actually need to change the law. I'm going to run you through an example of this in a moment. So if we do need to change the law, step 3 of the treaty making process is that the Parliament needs to get involved and the Parliament needs to change the law. And depending on the area of law, this might be the Commonwealth Parliament or it might be the state and territory parliaments. So we know the division of powers splits up lawmaking responsibility over certain areas to the states and the Commonwealth. So depending on what the treaty's about, we might need the states to change their laws, or we might need the Commonwealth to. Sometimes those states are unwilling to change their laws based on the action that the Prime Minister has taken, because they don't agree with it. And that poses a tricky question of what happens if we sign up to an international treaty and then the states refuse to change the law to meet that treaty. And it's actually been established by the High Court that the Commonwealth can pass its own legislation, even if it's an area of residual power, to meet the terms of a treaty and override the state's laws. And this is a controversial thing, a controversial topic, and this is the case we're going to go through in a moment to show how that works. Just to summarise with the use of an example, as I said, there is a treaty in place that 197 countries have signed called the Montreal Protocol. It's got a full name with far more words to it, but it's effectively about protecting the ozone layer. So those of you who don't know what the ozone layer is, put on my scientist hat, and I'll probably be very wrong here, but it's kind of like a part of the atmosphere that protects us from UV rays, so stops us getting fried, I think. And they discovered in like the 70s and 80s that there was a section of the ozone layer that basically a hole was opening up that was being depleted. It's over Antarctica, I think. And they believe that this was due to things called CFCs. So they're chlorofluorocarbons or something like that. So they're a chemical compound that the creation of sends up these harmful gases and gets rid of the ozone layer, whatever. The international community decided that we obviously need to protect the ozone layer so we don't all die, and we should limit the production of CFCs. So they proposed a treaty. That treaty puts a limit. Everyone who signs the treaty says that in our country there will be less than this amount of CFCs produced every year. And we signed up to it as a country. Australia signed up and said, we think that's great, we're going to protect the ozone layer. So that was the role of the executive, to sign that. So they signed it. Then we looked at, is legislation needed? And the Commonwealth decided, yep, we need to pass a law that forces corporations in our country to no longer produce CFCs. So they said production of CFCs is basically banned from this point on. I think they banned it, or they either limited it, something like that. So they decided legislation was needed, and then it was the role of the Parliament to actually pass a law that said CFC production in Australia is limited or not allowed. So that's just stepping you through the process. The executive signed it, we ascertained if legislation was needed or not, and then the Parliament passed a law to enact it. Tick, tick, tick. The Parliament sometimes, as I said, might need to pass a law in an area of state power if the states are unwilling to change their own laws. And it does this using Section 51, Clause 29 of the Constitution, which says, the Parliament shall, subject to this Constitution, have power to make laws for, etc., external affairs. And if we quickly flick back to our key knowledge dot point, we are looking at the interpretation of this section of the Constitution. So we are looking at what does external affairs mean, and how does that impact on the lawmaking power of the states, or how does that impact on the lawmaking power of the Commonwealth, So we'll go to a case in a moment. I'm jumping ahead of myself. Thousands of treaties. I think there's a treaty library that I'll link you to later on, where you can look up treaties that Australia signed. I think we've signed about 1,100 treaties since 1980. So there's like literally thousands of treaties out there. This is the signing of the Treaty of Versailles, which ended World War I. That's a treaty we were a signatory to. Some other important ones, or not so much important ones, but treaties that are out there. International Covenant on Civil and Political Rights. That's the one I talked about that kind of enforces the Universal Declaration of Human Rights. International Treaty on Plant Genetic Resources for Food and Agriculture. So like basically, genetically modified foods. What are some of the parameters around that internationally? An Arms Trade Treaty, Convention on the Rights of the Child, so laws around or international standards around treatment of children, particularly important for countries outside of Australia that perhaps have child labour, child soldiers, that sort of thing. And then the Montreal Protocol, which I talked about around CFCs and the ozone layer. So we can see the different names here. This one's a covenant, this is a treaty, this is a convention, this is a protocol. They're all treaties. Different names, but they're all treaties. Let's look at a case. So I want to focus specifically on how the external affairs power has been interpreted by the High Court to effectively give the Commonwealth more power. And a really, really clear example of this is what's known as the Tasmanian Dams case. And we're going to unpack that in the exact same way we unpack Brisbane and the exact same way we unpack the Roach case. So facts, legal issue, decision, impact. The facts for this one are quite broad because there's a few steps that took place in terms of a bit of a timeline. Effectively, in 1974, we signed a treaty. This one's called uses the word convention. That treaty we signed was the Convention for the Protection of World Cultural and Natural Heritage. AKA, we signed up that said, if we've got some areas in our country that are super nice and super cultural and stuff like that, we will make sure that we look after them. That treaty included a list of things around the world that were considered cultural or heritage sites. So it actually said, these are the sites in your country that you need to protect. In 1982, the Tasmanian government decided that they were going to dam the Franklin River. So the Franklin River is in southwest Tasmania, really, really beautiful, rugged area. It's one of those fast-flowing rivers that goes through, rock chasms and gullies and stuff like that. And they were going to put a dam across it, which was going to cause a lake to form and flood up, and they were going to use that dam to create electricity. Many people were worried about the environmental impact of this, and effectively at that time, to prevent this, an application was put forward to make this area a World Heritage Site. And shortly after the law was passed to build a dam there, UNESCO declared it a World Heritage Site. So they said, actually, this is a World Heritage Site. This is something that needs to be protected. So as a result, the Commonwealth Government passed a law in 1983, start of 1983, that said, it's called the World Heritage Properties Conservation Act, and it basically said, because we are a signatory of this treaty up here, anything that is deemed a world cultural or heritage site has restrictions on what can and cannot be done there. The law in this country now says that if something is a World Heritage Site, you cannot build a dam. It had a lot of other things as well, but one of them was you cannot build a dam. And this was specifically speaking to the situation in Tasmania. So the Commonwealth have made a law that stops the states from building a dam on the Franklin River, even though electricity production and environmental law, which is the key thing here, are not federal powers. So they're not listed in the Constitution. So they've made a law in an environmental area, even though that's not a power they hold. And this is going to be the basis of a legal challenge. The legal issue at hand was the Tasmanian government, as I just spoke to, argued that the Commonwealth government did not have the power to make laws regarding the environment. Therefore, they could not pass this law that restricted the dam. They couldn't pass a law in the area of environment. The Commonwealth, on the other hand, argued that the external affairs power, which we've spoken about just before, did give them the power to make this law because they had signed up to a treaty. The treaty said we need to protect World Heritage Sites, so they had passed a law that was enacting that treaty. So their law, step 3 of the treaty making process, their law was enacting that treaty and making it enforceable in Australia. So the treaty says we've got to protect World Heritage Sites, so they passed a law that said you can't do this to a World Heritage Site. Tasmania said, yeah, we can, because you don't have power over the environment. I want to quickly note this picture. It's dulled up a little bit in these slides, but if you wanted to look it up, the picture is called Rock Island Bend, and it was a picture taken, this is of the Franklin River, and it was a picture taken, I forget the guy's name now, and I should reference him, and I'll put his, in the comments for the on YouTube, I'll put his name in as credit for this image. But he took this famous image as part of the campaign to prevent the dam being built. And this image was displayed in the Sydney Morning Herald in Sydney, one of the biggest papers in Sydney, and the Age in Melbourne, as a double-page colour advertisement in 1983, I think it was, basically saying, you know, do you want to build a dam on this? Like, look how beautiful it is. It's a really iconic image. It was turned into a massive electoral issue for the federal election about who would get voted in. The Labor government that was voted in 1983 under Bob Hawke was very, very adamant that if they were voted into power, they would stop the dam being built. And a lot of people believe that that's part of the reason why they got voted in on the back of the environmental vote. And this image was really, really key to that. So beautiful image. It's called Rock Island Bend, and I'll post a reference to the photographer in the comments below. What decision did the High Court make? The High Court found in favour of the Commonwealth. They said that the World Heritage Properties Conservation Act was valid and that the Tasmanian government could not build a dam on the Franklin River. They established, and I say established, but they also continued, because there were previous cases around the external affairs power from as far back as 1935. But they continued to establish this broad interpretation of the external affairs power, aka external affairs should be interpreted to give the Commonwealth the power to legislate over anything of legitimate international concern. If there is a treaty on a particular matter, then this suggests that the matter is of legitimate international concern. So, aka, treaty on it, doesn't matter if it's a state power, you can make laws regarding that, the Commonwealth. What's the impact? Well, just that. The Commonwealth has the ability to legislate on any matter covered by a treaty, even if it is an area of power left to the states. So if it's covered by a treaty, Commonwealth can make laws on it. This could effectively lead the Commonwealth to having lawmaking power over anything, provided there's a treaty. A treaty is considered of legitimate international concern, they can make a law over it. This interpretation of external affairs, as I said, it was a further development of earlier cases. So one to look up is R.V. Burgess from 1935, that's about aviation, or Kuwata versus Bieki-Peterson, which is a case from a year earlier in 1982, and I've got a link to a video on that one. Again, both of those cases were related to international treaties and what external affairs meant. The decision in Tasmanian dams was also subsequently influential in a famous case called Croom v Tasmania, which led to the overturning of Tasmanian laws which criminalised homosexuality. So this was from 1997. Tasmania still had a law that said effectively sodomy, which is anal sex, was illegal, and in 1994, a few years before this, a gay man in Tasmania called Nicholas Toonan came out and said that this law was discriminatory. It regulated or criminalised acts between two consenting adults, and he asked the Human Rights Council to basically rule on whether it was valid or not. The Human Rights Council determined that the law was invalid, that Tasmania should overturn it because it was in conflict with Australia's commitment to the Australia signing up to the International Covenant on Civil and Political Rights. Tasmania refused to overturn their law. They said that there was a law based on moral grounds and they would not overturn it. This is 1997, so just before some of you were born. This is how recent this was. So Rodney Croome took the matter to the High Court, and he said, because the Commonwealth passed a law that said that sexual discrimination between two adults who are private consenting individuals is illegal. Croome went to the High Court and said the federal government made this law under their external affairs power because they are signed up to the International Covenant on Civil and Political Rights, and the Tasmanian law that restricts sodomy is in conflict with it and should be overturned as per section 109. Tasmania tried to have the case thrown out. They said, we don't enact the law anyway, but it's just there because, we morally believe in it and we're trying to stop HIV and AIDS and all these sorts of things. The High Court said, no, we will hear the matter, and Tasmania subsequently decided to change the law because they knew, based on this interpretation of external affairs, that their law would be deemed invalid and would have to be thrown or would be thrown out. So we can see how this interpretation of external affairs is the idea that the Commonwealth can pass a law in anything covered by a treaty has been influential on further cases in the future. This is the skill. Discuss the impact of international declarations and treaties on the interpretation of the external affairs power. And this is the question that was asked in the VCAR sample exam. So this is from the sample exam. Explain how the High Court's interpretation of the external affairs power in relation to international treaties has had an impact on the Commonwealth Parliament's lawmaking powers. So worth 4 marks, so an interesting question. And basically, to summarise, the way you want to answer this and to summarise this entire set of slides is this. When the Constitution is established, we have a division of powers. Some powers went to the Commonwealth, the remainder of powers stayed with the states, and one power particularly that went to the Commonwealth was, hold my computer, was external affairs. Okay? Pretty straightforward. The executive government, led by the Cabinet, Prime Minister and Senior Ministers, also has the power to sign treaties. And if needed, using their external affairs power, the Commonwealth can pass legislation to enact these treaties. So pass legislation that is based on what the treaties have asked them to do, even if this is in an area of residual power. So the Commonwealth can pass laws in areas of residual power, provided they are covered by an international treaty. Let's look at our question again. What impact has this had on the Commonwealth's lawmaking power? Well, pretty simply, this increases the Commonwealth's, this increases the Commonwealth's lawmaking power as they are effectively able to legislate on anything provided it is subject to an international treaty, and regardless of whether it is in the Constitution or not. AKA, doesn't matter if it's a residual power, if there's a treaty, the Commonwealth can make laws on it. To build that answer up, you might want to reference the Tassie Dams case. You might want to say, obviously in the question we talk about the High Court's interpretation, so you would want to say that this is the interpretation the High Court has come to. The High Court has said that's what external affairs means, and that the Commonwealth can make laws in any area covered by an international treaty. It is worth noting, just so you are aware, that in most of these cases, the High Court was really split. So there's 7 justices in the High Court. Every time they get a case, all 7 write their own judgment and decide for one party or the other. And basically, it's a majority win situation. So if 4 go one way and 3 go the other way, the 4 win. In pretty much all of these cases, Tassie Dams included, Kuwata and Pieki-Peterson, 4 out of the 7 said that external affairs should be viewed quite broadly. So anything under an international treaty is covered by external affairs, and the Parliament's able to make laws on. But in all cases, there were actually 3 justices who dissented, who went the other way. So there was a view from some High Court justices that external affairs should be seen as much narrower, that not every international treaty should be considered as of legitimate international concern. Not every international treaty should be able to overrule states' powers, and that there should be a further test that the High Court would implement to restrict that, or to test whether the treaty was of enough concern internationally or not. And that's a view a lot of people in society, in political circles, still take. And there is a view that this interpretation, as it currently stands, is really detrimental to the states. It continues to erode state powers and remove responsibility for lawmaking from the states, and vest more and more power in the Commonwealth. And a lot of people see this as a bad thing. They want states to be able to make more laws on local matters. And this goes in with a further argument on the idea that the Commonwealth government collects most of the tax these days through income tax and GST. So they then pass that money on to the states. And the idea that the federal government is just becoming bigger and bigger and taking on more and more responsibility, and through international treaties, as the world becomes more interdependent and we need more treaties, they are able to take more and more power off the states. And it's a view by some that this isn't okay. It's a view by others that this should be the way, and perhaps state governments are obsolete and we don't need them anymore. But ultimately, what is the impact on the Commonwealth Parliament's lawmaking powers? This interpretation increases their lawmaking powers because they can legislate on anything that is subject to an international treaty, regardless of whether it's a state power or not. Here's some links I'll post below. Same link from the last one. So it's got a video on the Tas Dams case and a video on the Kuwata case, which would be interesting to look at. Kuwata is about, it was a case brought by John Kuwata, an Indigenous man from Queensland, from the Wik people. They wanted to buy a large area of land that was on their traditional lands from a pastoral lease, and the Queensland government said no, that they couldn't buy it because they didn't believe that Aboriginal people should be able to own land. This was from late 1970s, and the case was brought in 1981. So he took that to the High Court and said that it was against the law for them to be restricted from buying land just because they were Aboriginal. So an interesting case. External affairs comes into it because we talk about a treaty that the federal government had passed. The treaty making process, which I broke down into 3 steps, you can find in great detail at the DFAT website. As I said, there's an Australian treaties database, so you can search up any treaties we're a part of. If you want to know more about the Montreal Protocol or any of those treaties that I listed, you can actually look them up. And I've gone early there. And I'll also link you to a 1996 report from the Senate Standing Committee on Legal and Constitutional Affairs, who basically wrote a report into the external affairs power and whether they thought it was its current interpretation was good or not, and whether we should have a referendum to change the external affairs section of the Constitution to either narrow it or even potentially broaden it. As I said, a tricky one. the impact of international treaties on the interpretation of the external affairs power. Hopefully you can answer this essential question. If not, look to further resources, look to those videos, go back over this, notes, that sort of thing. But hopefully you can say that this has broadened and extended the Commonwealth's power because they can legislate in any area that there is an international treaty on. This has been another video for the Legal Studies guy. Subscribe to us on YouTube. If you're watching this on YouTube and you haven't hit the subscribe button, please do. It really helps make sure that you know when new videos get posted and that sort of thing. Give us a like on Facebook and send us any feedback you have. Happy studying and good luck for SAC 4.1. I know you'll all do wonderful and yeah, you're all going to not just be good, but be great.